Hello, I'm Victoria Green. I am a senior barrister at 1KBW. Those who don't know me, I specialise in public and private law children cases, many years' experience in both of those fields. This is part of our 1KBW series of Going Beyond the Threshold. We are now turning to looking at post-adoption contact. And some of the changes that have been happening in respect of that, particularly case of re C, D, E, and F, and the increasing move away from closed adoption. So I'm delighted to introduce Fatima Ismail, who is going to explore that topic and consider how the courts are really now increasingly starting to deal with that post-adoption contact issue. Fatima, like lots of our members of chambers, practices across the whole range of family law. She regularly appears dealing with public law children cases, acts again for all parties, local authorities, parents, guardians, interveners, and so forth. So she'll talk for around 10 minutes, and then we might have a little discussion about that.
Thank you very much, Victoria. So yes, thank you. I'm going to be talking about the very important topic of post-adoption and contact. So just as a reminder, the court power to deal with this issue is set out in section 51A of the Adoption and Children Act 2002, and the principles that underline that decision are quite similar to those set out in Children Act 1989 legislation, and those are the welfare principle, the welfare checklist, and also the no order principle. And these are all the elements that the court will be looking at when considering the issue of contact. Just turning to that specific case, which was quite recent, it was a 2025 decision, and facts of that case involved two sets of siblings who were aged between 8 and 3 years old, and they were part of the same family but had been adopted by two separate sets of placements. And in the substantive proceedings, it was quite interesting to note that the Guardian's final analysis specifically described the importance of ongoing direct contact, and the Guardian in that case said it's essential that the two pairs of siblings have direct contact throughout their lives, and that was recommended to the court. And in that decision, the court made an order under section 26 of the Adoption and Children Act 2002, requiring the local authority to ensure that the adopters facilitated direct contact. Unfortunately, what then happened was that that order was completely ignored by the local authority, and when the case came back to court to make the final orders for adoption, the court was very concerned to learn that there was no direct contact that was taking place, and effectively that was considered by Her Honour Judge Reardon, and the outcome was that all four siblings needed to have direct contact, and a section 51A order was made. And the reasoning behind that can be explained in three ways. The first was the court looked at the welfare-based necessity for sibling contact, and the judge found it quite compelling when looking at the welfare reasons behind for keeping the sibling contact alive and the relationship alive as well. The judge in that decision said direct contact between siblings would provide the best insurance against any feelings of loss and dislocation between those children and their birth families. The second reason was a lot of the judgment focused on local authorities' failures to support contact. They were criticised specifically for their confused and inconsistent approach, and the fact that they'd ignored the section 26 contact order. the final issue was about the application of the no order principle, which of course we are all alive to, and there was very helpful discussion in that judgment about the no order principle, and the fact that I think it's paragraph 52 of that judgment, there's a real conundrum that the court is often faced with about whether it's appropriate to make an order for adoptive parents to have to adhere to, and what, if any, circumstances would it be appropriate to make that order? I think the answer is quite nicely set out at paragraph 59 of the judgment, and it can be distilled into one thing, which is, if there are compelling welfare reasons for keeping that sibling relationship alive, then an order should be made. Now, how do we go from there in terms of that judgment? Well, I think the case is really helpful in that it highlights the court's approach and the shift, as you say, Victoria, from keeping contact effectively as only letterbox contact to making sure that siblings and adopted children have that connection to their birth family in any way that they can, as long as it's safe and it's within their welfare best interest to do that. In terms of looking forward and how this judgment is going to be interpreted, I think there's now a lot of information and material available to suggest that the previous approach is no longer fit for purpose. And in looking at this, I think it's really helpful for those that are faced with these types of issues to consider the wider material and not just the authorities on this. And I refer to a really interesting report that was produced by the Public Law Working Group, and specifically Chapter 1, which addresses the issue of contact. It was a report that was produced in conjunction with senior members of the judiciary over a 4-year period, and the report makes a number of really helpful recommendations which highlight the difficulties. The report effectively recommends that there needs to be a tailor-made approach to contact, which is adapted to meet each child's specific needs, and that contact should actually be considered throughout the child's minority, not just when an adoption order is being considered. There's also been a change in the authorities. I think there's a really helpful resource on the government website, which is a table that sets out all of the authorities on this issue, and I'd really recommend that is looked at. There's a specific authority of Mr Justice Moore from 2015, and it sets out very interesting statistics on the issue of post-adoption contact. There was a case study that was carried out, and effectively it found that in 11% of cases there was no contact at all. In 80% of cases, there was letterbox contact only, and then in 17% of cases, there was direct contact, but only 9% of those were with the birth parents directly. So really quite stark statistics there. And the reasons that are cited throughout the authorities in that table generally were that usually an order for contact would be too onerous on the adoptive parents, and the general idea that if there is no contact with the birth family, then that was a protective factor, and it would prevent destabilisation of the placement. Now, moving away from that and thinking about the decision that we've discussed today, there's clearly some form of shift, and the report itself, in conjunction with this decision, really highlights that there needs to be a move away from letterbox contact, and the tailor-made approach that I referred to earlier. We're also told as part of that report that there needs to be an increase in face-to-face contact between adopted children and their birth families, not necessarily just their birth parents, but in particular their siblings, because of course they are not necessarily in the same placement or within the same adoptive family.
So Fatima, I think, in certainly my understanding, and we represent local authorities and talk to them about the sort of training that's now being undertaken with prospective adopters, is that there is a real shift now to talking to prospective adopters about the real positives and benefits to children of maintaining relationships with direct contact with birth families. So certainly I've had any number of cases where I'm told that actually, including in a care plan, that there's going to be, or the anticipation hope is that there can be some direct contact. It isn't unrealistic because that's what prospective adopters are now being trained in respect of. So I suppose if we're thinking about that, and you talked about the no order principle. So why would a judge, do you think, perhaps think about, well, making a contact order in circumstances if there were willing adopters willing to facilitate that contact?
Absolutely. I think that's the issue that the judge was faced with in that decision we spoke about. And I think it's really helpful to think about it in two different ways. For the child, it really marks the importance placed by the court on maintaining the relationship between the adopted child and their birth family, whether that be their birth parents or their siblings. It also fortifies the adopters against any future difficulties that they face, because of course in the decision that we spoke about, there was a lot of criticism against the local authority for not being able to comply with the Section 26 order, but we are later told in that judgment that after the decision was handed down, the adoptive family contacted the court and told them that they didn't actually know that there was an order in place, and so that's a real difficulty. It effectively operates as quite an important safeguard for the child. And even if there is agreement about contact, it gives the child that reassurance by keeping that relationship central to their welfare. And then, of course, if we're saying that if the adoptive parents are already willing to agree, then what benefit would an order have? Well, it provides them with the appropriate support that they could be getting from the local authority, especially when there are local authorities that perhaps aren't able to comply with Section 26 orders, for example. So in that particular case that we spoke about, the two families didn't actually know each other, and so they needed that contact order to make sure that contact actually worked.
So just thinking then about the case that you've been talking about, kind of flow from that, what do you think in terms of issues that are arising from that case, or tips that you can give to anyone advising on these sorts of issues?
Absolutely. So I think the first thing to always remember is that birth relatives cannot automatically apply to the court for contact. They do need permission. They need to seek that first. So that's the first hurdle effectively to get through. The second is that contact can take place in many different ways. And of course, it's very easy to rely on the very typical letterbox contact scenario. Different types of contact should be considered and explored properly, depending on the child or children's needs. It's not a binary system.
So be creative.
Exactly. And I think one thing that I would say is really important to consider is that each case is very fact specific and sensitive, and a child's needs need to be balanced, and adopters, of course, may feel anxious about contact, but they need to be kept in the loop and they need to be kept in the conversation, and documents should be shared with them in a timely manner, because they need to be able to provide their views, and those need to be canvassed by the court in order to make sure that any contact order that is made is workable and it is realistic. And the final thing I would say is enforcement is an issue in these types of cases, and although it is an issue, it is not a barrier for a contact order to be made.
Thank you. Thank you, Fatima. That's really useful and helpful, I hope, that others will find. Very much hope that you'll be able to join us again for the next session and indeed future sessions, which will continue to explore what we hope will be interesting and useful topics, challenging areas of public children law. Thank you.